It has started, Mr. Kumeta.
Okay, thank you. With that, I'd like to then welcome the public that may be following us on a number of our platforms. NASA platform 3, the meeting is scheduled to run between 9 and 12, and the agenda was published. So if anybody is following us, we then go straight to agenda item number 5. For most of them, there may be others where we may, give you slightly more time for the introduction. But for most of the items, kindly limit the introduction to 2 to 3 minutes. Just take the item as read, like the key points that might be relevant. So agenda item number 5, Mr. Mavuso.
Yeah, the agenda items up to 9 will be presented by, supported by especially 1 to 3. The risk rate in terms of reduction of the premium. Then if the rate goes down, then this has to be passed through to society to achieve equitable outcomes. So in the main, Chair, these submissions for reduction are based on that consideration. Thanks very much. Senator, can you please assist and introduce each submission? Thanks very much.
Thank you, Chairperson. The purpose of this submission is to read Rubicept RFPTY Ltd, Firefly Investment 253, RFPTY Investment Holding 79, RFPTY Ltd, and also to request Electricity Subcommittee to approve the amendment of the Power Purchase Agreement. All were licensed on 26 April 2012 under bid window 1. As Mr. Mavuso has mentioned, for the bid window 1 to 3.5 created a perception that the tariff were overpriced in the PPA to the detriment of customers. Since the initiation of the refinancing protocol in 2020, 15 IPPs applied for tariff reduction and were granted approval. The consideration of the amendment of the existing PPA is delegated to the Electricity Subcommittee as per clause 112 of the delegation matrix. The financial information in all 5 applications is confidential. We therefore recommend to the Electricity Subcommittee to approve the recommendation as set out in the submissions. Thank you, Chair.
Thank you. Members, you've got the item before us. Again, Ms. Mukwanas, if I can clarify, for the other 4 items, you just go straight to the salient point on each and the recommendation, because the actual introductory remarks are similar, correct?
Yes, they are.
Questions or comments for the team on this particular item, maybe even commenting on the overall comment that was raised or the issue that was raised by Mr. Mavuso and also highlighted by Ms. Mukwanas. Any questions, members? Okay, I don't see any hands. Oh, Mr. Mkiza.
Thanks, Chairperson. Just pardon my voice. I'm still recovering. I would just like to understand whether the tariff still remains confidential. That is confidential everywhere. I thought the tariff itself will not be confidential. Maybe other matters would be, and this endeavor is appreciated from a point of view of lowering the economic impact on the part of the consumers. That's the only thing. Otherwise, I support all of this submission. Thank you.
Thank you, Mr. Mkiza. Is the tariff still confidential, and perhaps indicate why? I see Mr. Hore would like to assist you. Mr. Hore, if you can assist.
Yes, we think it's confidential because there are still negotiation is not the same on all of them. So we think that for not to be not to be leaked, at least they should remain confidential. Thank you. Thank you.
Thank you, Mr. Hore. A follow-up question, Mr. Mkiza? I recognize and welcome Mr. Pokula. You haven't missed much. We were just concluding item 5 in terms of questions. So we are just about to go into a vote. So members, with no further questions on item 5, can I just see by show of hands if we can approve the recommendations without mentioning the numbers, but you've got the numbers in front of you. By show of hands, members. Mr. Mkiza, I note you. Madam Massetti, Sibia. I know I also support Mr. Pokola. I know you've just joined, so you will not be able to vote on this one. With that, can we then move, Ms. Mkwanazi, if we can just highlight the salient points on this one and then take us to the recommendation, please. You are on mute. Mr. Horace seems to be struggling. Can you assist?
Okay. This one is also the level of the tariff reduction as indicated on the recommendation. So there's nothing really that is so different. Tariff reduction, and again, the gain is also from the refinancing, where the licensee managed to get a cheaper rate than what was granted at licensing.
Thank you, Mr. Hora. Any specific questions, members, on this particular item, similar to the previous item? Show of hands.
Take any public consultation process? If not, do we have maybe a legal requirement in terms of Section 10 that NERSA, before it takes any decision, it must follow the due process? Thank you.
Thank you.
Yes, Chair. If you look at paragraph 31 to 33, there's the legal analysis on why we didn't do the consultation process, because this application is actually based on the financial information that is to be confidential. So 1 to 33. Thank you, Chair.
Thank you. Can I maybe just also add? I mean, as we know that the tariff that is being applied was actually a product of a public tender, rather than a product that, because we don't, it wasn't really our own process that yielded that price, but rather a public process in respect of a bidding process arrived for us by the market itself. So I think that we should also always remember that these are product of public tenders, rather than something that was actually as a result of us in there in terms of era. I guess yes, you're correct. No, yeah, sorry, I actually got it wrong. But Madam Assetti, I see you've got a follow-up.
Yes, I do, Chairperson, and perhaps it is also something that will be going forward. The fact of the matters, there is no other body that can take a decision on tariffs for electricity except us in terms of Section 15. So irrespective of the initiative that has been taken, which I will class it off NERSA's processes, once then it comes to NERSA, it requires of us to apply ourselves properly to the issues and therefore take a decision. So I raised the question regarding the compulsory consultations before we take every with regards to statutory consultations. Thank you, Chair.
Amendments of the schedules, Schedule 2 and 3s, and that we actually need to satisfy ourselves, and maybe we must have a proper reason why for the amendments that we shouldn't actually have a Section 10 process. I guess of their license, but this is also a condition of license. So if I can just ask LAS and maybe RSU to assist us with this, to say, so that we can have a proper decision on this, on whether do we need to consult on these on these amendments or not. We need to be cognizant of the amount of work that would raise, and also in terms of whether is there any value in it. Your input, sir?
Chairperson, may I by legal?
Rati, Mr. Chokwe? The amendment of licenses, or should I ask Mr. Murati placed between the two of you?
Chairperson, let me start first. Murati may. It's whether the decisions that we are actually taking, they can actually materially and adversely affect the rights of the public. But that's the call that we should make. I'm talking General Murati, I think, will come and talk specifically to the issues. I'm talking a principle to say, when do we consult? It's that when, in terms of PAJA, is when our decisions, they can actually materially and adversely affect the rights of the public. And we are the administrator that we must make a call whether indeed we think there is materiality
to approve the tariff approved between an IPP or a bidder that has secured the right through the whatever the bid contracts of the parties for the sustainability of the decision. In this regard, the parties that are involved, it is the buyer and the IPP, and as such, they have agreed settling the issue. So therefore, when it comes to NERSA, is the satisfaction of the mandate windows, in particular the recipients, are not the tariff that is charged to them. It forms part of the basket that when we deal with the tariffs of ESCOM or the buyer, that is when we consult the broader public. And Chair, if I may just close it by saying, when the courts have touched on this issue, that when dealing with the ESCOM part, that is in the Bobet judgment, where the court touched on that aspect. So in this regard, the section 10 of the ER of NERA, it's satisfied by, and PAJA as well, it's satisfied by parties, therefore can bring a written part on that matter as a matter arising. Thank you, Chair.
Thank you. But Mr. Murati, a point that's been asked by Madam Massetti on the chat, that says, at the end of the day, the resultant tariff has got an influence on the tariffs that are charged to the greater public. And therefore, I think it would assist if we can provide us with something in writing to assist this in terms of this decision. Because at the end of the day, whatever that the single buyer might have translates through into the bigger price. And I think when you do this, if you can also, as you provide that written response, the emerging issues, including data, the net billing effect, because that's also going to come in. It will have the same effect that says, although whoever is buying the power, that contract between him, whoever the licensee is, it might be a bilateral. I'd also ask the second question, Mr. Murati. So in this particular one, you will write up something for us, and can I then maybe just ask when to believe that would actually be Pogoda?
Thank you, Chairperson. Chairperson, I may use the wrong sections of the Act, but I think in the updated one that I have, I think it's section 46 that I first want us to go to. Section 46 is the one that talks about, I know there's talk about section 30, the new generation capacity. Do I have the right Act?
It is 35 now.
It has got section 1 that talks about all of these things that have been done for us to get to this point of having the tariffs and approved PPAs and part is to issue the license. I mean, we don't get into the space of deciding the tariffs because the tender of that section is we are bound by any determinations that are made by the minister under subsection 1, which is the one that talks about the tender. So this particular development of tariffs changing, and yes, it's a change. The amendments of license conditions we do consult, but the point I'm trying to say is that because this part, section 3, that says that when we're issuing that license, we are bound by any determinations that will be made by the. For instance, we are bound, even if we consult, we are not going to change anything. it is part of those changes, as much as they are that. And that's my contribution, Chairperson.
Thank you. Just to expand on that, I think the challenge here, and Mr. Murati, when you come back to us, you need to talk to this one again. That the challenge that we have is that because this we license these service providers, they become licensees, and therefore they are bound by Section 15.2. And 15.2 does not exclude them that emanated from Section 34. It is 34.3. Mr. Pokula, they are not bound to approve it because they, in terms of Section 15.2, they cannot charge any other tariff other than that has been set or approved by the energy regulator. It is in that spirit of us approving. But the question that then always arises is that in us approving, rubber stamp, or do we conduct some kind of analysis to say we've approved this tariff, but haven't gone through a particular process? If we do not go through a particular process, clearly, therefore, we should just be noted. But unfortunately, Section 15.2 is very specific.
Thank you, Mr. Gumede. Mr. Gumede, some of us, we got our law degrees from the University of Nersa, so you also need to take what we say with an understanding that Chairperson, is that the Section 30 or is it 34? The Section 34 says that these are the generators that would be contracted, and yes, the prices must be approved by the all prices by any determination. So it takes away that requirement of us to approve because we are bound by that. There is no PPA. I mean, in law, there's a contract between the two. We can't get in to say that they shouldn't have this or that. This is why I say that in particular, these contracts that came through that IPP process, our function would be to note those things, not because we're not approving them. And yes, it says that, but I think even Section 15 says no other. But Section 30 says no, when you are issuing the license, if it's been determined by this process, then you are bound by that process. And it is that we are bound by that process. We can't then go to Section 15 and change the processes. Bound as in that we would note and whatever the minister determined, we are bound by it. So there is a part that then through the tendering processes is going to set a price. Thank you, Chairperson.
Noted, Mr. Pokula. And therefore, Mr. Murati, that's one of the things that we need to, at least we as the regulator, need to affect and actually locate 15.2 correctly these processes going forward. Thank you, Madam Asset. Your follow-up, Madam.
Listen, I think we exercise our mandate. In terms of Section 15 read with Section 35 process, how our mandate is supposed to be exercised there. I say this because it is not the first time that it gets so that all of us were all aligned. It was asked in 2018 at the energy regulator level as to whether we rubber stamp when we deal with the procurement done through process. Do we rubber stamp Senior Council's opinion? So in terms of the legal interpretation, I think because it was accepted, yes, and they've done an analysis of what legal counsel is saying and the implications, and that followed by a submission. In essence, Senior Counsel indicated that NERSA is the only body that must determine the tariff. Senior Counsel went further to acknowledge minister's process. And Senior Counsel also advised that since minister leads this process in terms of Section 35, it will be important is assigned to NERSA. So it will be important even for Mr. Murati when he provided then that clarification to the ELS because it was adopted by the ER in the advice of Senior Counsel. So I wanted to bring that aspect in so that this issue is an issue that was dealt with before. NERSA paid money for it. Senior counsel provided an opinion. Legal services analyzed it, and we followed that advice. But I think the point, Bukula, they're also part of what was clarified. I think maybe there are two or so things that we need to get them right and be careful, especially when we're now doing an amendment. So we need to also look at then the amendment. Yes, it is part of that process, but and it's no longer just the tender, but let's look.
Mr. Mkiza?
Thank you, Chairperson. I think already the issue of the legal opinion that was once received was, and for me, it's a matter of reconciling Regulation Act with Section 15, which I think that could be crafted outside of this process. And we also need to underscore that these are just on the matter that was raised by Mr. Chogwe regarding the adverse impact, that the impact is not adverse in terms of the tariff itself, that all of these are moving towards it, to underscore that, as well as what Mr. Hore has put forth in terms of that these tariffs are being, in terms of the reduction, they are still confidential. But important to note is also how we need to work going forward involved into the approval in terms of Section 34, such that we can then be able to approve tariffs and not be rubber stamping. I will leave it at that, Chairperson, to say that I think it is sound enough in my own understanding as put forth before us, and but still they just need to polish up on the of not having a public consultation in terms of Section 10. Thank you.
Thank you, Mr. Mkiza. Thank you, members. I know this was a deviation from what is before us, but it was a necessary discussion. And Mr. Murati, if you can assist us with that. I think it's really just how do we, and if we already have a previous legal opinion on the matter, that will greatly assist, but you can expand a little bit further, because at least this part, okay, no, you're correct. It does deal with this, but I guess in the main is that when you write for us in this particular process, question that says I am and maybe not us, but to request that you also assist us with this. That when we do this, because we do a lot of this, and especially in terms of Schedule 2 and 3s, that is when a trader, for instance, or adds a customer, for instance. To the question is, because that's also amending the condition of license, are we bound to also then follow Section 10? If you can assist us with that as well, Mr. Murati, so that at least once and for all, we are quite clear that when we are amending, if we were to do all of just those amendments and we were to take them through a public participation, is value add, but also we need to consider the efficiencies of the process. Okula, you were going to raise a matter. You had raised your hand. Has your matter been dealt with?
Thank you.
All right. No, thank you. All right. With that, colleagues, we've and the request that have been made to LAS to expand, I guess, section that in terms of paragraph 32, it does talk to the process a little bit more. But having considered all of those members, if I can take you to a decision that it's a recommendation. The recommendation is on. Sorry, where is it? What page is it, Mr. Hore? I even got lost now. Oh, I'm actually in the, sorry. It's on 2. Members, by show of hands, can I see if you can approve? Thank you, Mr. Pokula. Thank you, Madam Spear. So you've got your decision there, Mr. Hore. I hope item 7 will go a whole lot more faster. Any salient points? Mr. Mukwana is first, if she are now available.
Thank you, Chairperson. This is application for the tariff reduction for request the Electricity Subcommittee to approve the tariff reduction and also option in the PPAs. Thank you, Chairperson.
Thank you, Madam. Members, any question, further question on this? Over and above what you discussed before? If nothing, then can I take you to the recommendation, members, which is in paragraph by show of hands, members? Can we approve? Thank you, Mr. Masiti, Mr. Pokola, and Ms. Sabia. I also approve. So you've got your decision there, Ms. Sabia. The next item 8, please, if you can proceed with that.
Yes, this is the application for Firefly Investment 523 to the previous one, and also the members' guidance are noted. And I
thank you, Madam. So members, I assume that there are no further comments, questions on this one. Can I then take you to page 5 of 6? Again, it's paragraph 14. That's a decision that is sought. Can I, by show of hands, see if we can approve? Approve the decision. Thank you, Madam Maseti. Thank you, Mr. Mkiza. Thank Mr. Bia and Mr. Pokola. You've got your decision. Mr. Mkanazi, sorry. Your last item 9.
Important even for the record that at least the title of the submission and then even the paragraph then of that particular submission, even if there are no questions asked, just for the record.
If 79 RFP2R Limited, it appears twice and okay, sorry, can I read this properly? The purpose of the submission is to request the Electricity Subcommittee to approve the refinance for Oakleaf Investment Holdings 79 RFP2R Limited, P2R Limited, in bracket calls Oakleaf Investment, the amended tariff. And that amended tariff is reflected under paragraph 14. It is, as indicated, it is confidential, so we're not going to talk to it. But it's that tariff reduction as well as the inclusion of that reduced tariff in the PPA for the record. So by show of hands, members, can you approve that? Thank you, Mr. His Vision Compliance Framework. Mr. Mavuso, who's presenting this one?
Chair, this will be presented by Jared, but just want to make a few comments to say that from time to time, work that we actually work under so that we can, enjoyment. And this one also was done in that context. And the aim also is to share the framework with the licensee, so to develop the quality and depth of compliance. And I think, Greg, can you come in just to maybe zoom in there that I have not mentioned? Thanks.
Welcome, Mr. Hopkins.
Yes, the purpose of the submission is to request the subcommittee to approve the Electricity Distribution Compliance Framework, which is Appendix 1. As Mr. Mavusa says, the investigations report into the process, which is part of our contraventions and penalties section, as well as the section of penalties was beefed up, and that's it. We recommended the subcommittee.
Mr. Mkiza?
Because it's not indicated that it is new or revised. So, and I think we had adopted a standard that when something is being revised, things where changes have been made. I found this to be more about also audits, which also makes things which I'll see it as a limitation in some way. Then when I go to 5.2 on compliance audit processes, is that you say that the last line there in the inspections will be postponed to a later date. I'm saying what if there are also other means that the requisite in 10 on independent compliance audits? It doesn't come out clear as to who will foot the bill there for those audit. or by any other means. I think it's important to have that included. Some of the things like on page 9, where you're talking is that first line to say roles and responsibilities of the licenses will be presented. I take it that this should actually say are presented. And then on page 7, I'm not so sure.
Sorry, is it me?
We can't hear him, so yeah, I think he's probably
Low chat.
yeah, yes, because it's 10 o'clock. That's correct.
Yeah, it is low chatting. I've also been low chatted. Mr. Mkhize, if you can hear us, indicate so. If not,
the process. Just from a process perspective, you this is as an annual process of monitoring the licenses performance. Or page on, is it working? Are there no issues with regards to that? Because I will assume that it where you actually looking at this monitoring, but also monitoring. But also, I think there is a section here, which is on section 4, independent compliance reviews. Those independent auditors, which is a process on its own to conduct the compliance audits. You actually then say that, or also the licensee appoint the auditors. Is that process I'm worried about that second one where the licensee appoint the independent auditors. What sort of mechanism do we have to make sure that that process is a fair process and it really will address what we are looking for? I see that you say it work, but how do you, were there no challenges in the past where I appoint an auditor who will then report on me? I'm looking at a sort of a conflict when it comes to that as a fairly new person. So that my concern was around that. Is that process working? For me, if ever we wanted to do the audit, we should, and then also deal with this issue that Mr. Mkhize was raising of funding such audits. But the issue of making sure that we appoint the independent auditors, make sure that they are the ones who can actually conduct these audits to our satisfaction as NESA, as we are the regulator. The licensee to appoint, for me, it's a bit of a scary one, but I just wanted some assurance from the team that it works and it has reached.
Thank you, Madam. By the way, you actually had your video on. I don't know whether that was intentional or.
Oh, sorry.
Yeah, no. It's okay. It's okay. I just thought, yeah. Okay. All right. Any other questions, members? Mr. Mkhize, are you back by chance? No. I think we've lost Mr. Mkhize. Hopefully he will join us as soon as he can.
Yes, I'm back. I'm back, sir.
All right.
My apologies. I was not aware of this load shedding. Otherwise, I would have made other plans such that there wasn't going to be this kind of disruption. So apologies for that.
No, that's fine.
I was just saying that on page 3, with the paragraph that says to ensure that this compliance is implementable, NERSA will continuously pursue integrated projects and programs to support and maintain the framework. My understanding is that if you've got a framework, you then advance or enhance it or improve it. So I think if you can just change the language to talk to that, so that you are always on a progressive path when it comes to the framework itself, and we also ensure that people do understand our framework and actually comply. Because at the end of the day, you can have a framework. The most important thing is the end product, which is compliance, so that there's stability in the sector. Thank you.
Thank you, Mr. Mkhize. Team, some of the input was for enhancement. The first one, is this a new or is it a revised framework?
Thank you. Yes, this is a revised framework. The first framework was submitted in 2010, I believe, to the ELS. It has been revised multiple times since then, but it was never submitted. So this is the first resubmission since 2010. Question about the site inspections.
Yes, but can you just talk to the issues? Ordinarily, when we revise a framework or anything, is that we normally submit a clean version and also one with track changes. Can we maybe just on mind that I think for the record, if we can provide the members maybe can publish a tracked case what changes were made to the old framework, please. Thanks, and then we can proceed. That's just a request for later on. You don't have to provide it now, but if you can have it published so that for the record members can be able to see what were the changes that were effected on the old one. Unless,
Yes.
of course, you just want to briefly talk to those. What were the changes that were made to the old framework?
No, I think procedurally we should send the members the original framework and the track changes version.
Than the one with track changes. But the major change that was there is to include the enforcement part, or what do you do after having audited the licensee and the licensee is actually not implementing or rectifying those non-compliances. You would remember that during the consolidated compliance, the colleagues would always highlight the non-compliances and the licensee is not implementing the corrective action plans. So that was the major issue that we put, and it also goes on to the tribunal issues and the tribunal issues, as well as the investigation that was included in the
question on section 5.2, the site inspection. The question was, is there no other way apart from doing a site inspection? We can have a look at that, but if you want to look at the general condition of a network, the only alternative would be I don't see a way around not doing site inspections.
And the answer to that is no, right? It can be site inspection plus any other. We can have those virtual meetings, right?
Yes, it's not excluded. No, it's not definitely.
Okay, I think that was the issue. It wasn't. Yeah. Okay. If we can proceed.
Yeah. It's not clear who will pay for it, and there was a question about having the licensee pay for independent audit. How would that have do a complete technical review of the system for their own maintenance purposes, and we can use that as a de facto independent audit, which is not really what we had in mind with independent audits. The answer is no. We have never had to do their own independent audit in the past. This just allows the possibility of that scenario to take place. I hope that answers the question.
Thank you. I saw Mr. Marati's hand came up a little bit. Were you wanting?
Chair, just good. Sorry, probably. I don't know whether when the document is approved. I just wanted to do maybe something that we don't normally do, because our comments should have been made during the development of the document. Unfortunately, we didn't have sight of it, but maybe from an experience point needs to be enhanced to deal with the issue that we have to date had 4 court cases that all of them they had criticized how the time that it takes with our audits and the follow-up during the corrective action plans, that the monitor that it takes to remedy the situation that customers are complaining about. to have maybe the timelines of audits shortened and the reaching a point where because some of them, the decision of the regulator does not feature on those, that maybe we would need to bring it to the colleagues at ELC to enhance the framework before they kind of like finalize it to have it signed off. Thank you, Chair. But I would apologize to have to raise it in the meeting now, that we would have raised it at the time. Thanks.
Okay, thank you, Mr. Murati. But there is if you can just look at the comment by Mr. Horia on the chat. Madam Maseti, before responses.
Yes, Chairperson. Thank you, Chair. Chairperson, I wanted to is because I think it will be very helpful and beneficial to the members before any taken, that at least LAS has sight of this document, and I'm surprised that the HOD from LAS has not had that opportunity to look carefully at. He is the one that assisted the regulator in all of these matters that go to court, and with his experience, at the end of the day, we must have a document that at least has been scrutinized so that we are comfortable. Or maybe some other challenges within the process. But I would have been much more comfortable that such experience that we encountered over the years on matters that had to land in courts, that at least this document tried to address those things and be much more transparent. And that input from LAS incorporating the approach that NERSA must take, learning from the experience, for me, is very critical, Chairperson. So I wanted to just raise that aspect and see maybe what is the most efficient way of dealing with this matter, or effective way of dealing with this matter, at least to make sure that from LAS is there. Thank you, Chair.
Thank you, Madam Maseti. Mr. Nkiza, follow up.
Chairperson, I think I'm partly covered by what Madam Maseti has said. I would prefer that to delay, really. Even if it means must be round robin, it's fine for me. If it's very urgent, because you also need to get this document like a 2010 version, and there's some version that were happening between. Also need to be able to deal with issues of version control. I don't know document standards, and include the time frame within which it is expected to be revised or reviewed, I mean. And then just to indicate that important to, as I say, we're on a continuous improvement path, and that aspect should always feature. Due consultations with to also consult with the other regulatory divisions from a point of view of not just saying that in frameworks, and we kind of standardize on those things, and we make it clear to our licensees as to what is expected of them. And I think that there would be a process also where if they open up for improvements in terms of the understanding of the framework. I will leave it at that, Chairperson. I don't want us to delay on decisions, but at the same time, I just think it's important to take all these things into cognizance. Thank you.
Thank you. Mr. Hopkins, if we can continue with your responses, taking into account the further input from members, and also just, I guess, the fundamental question is the urgency for the approval of this process, or can it be delayed a little bit so that we can incorporate input from other divisions and also from further input from LAS, noting the point that's been raised by Mr. Hore on the chat. But over to you.
Yes, LAS was quite extensively involved. Maybe not as involved as the HOD wanted it. As for the urgency of this, no, there is no deadline for this. There's no timeline. We will continue operating as usual. We can. There's no urgency. It's more time, and once more consultation with LAS, etc., we can do that. The other question, I think I answered all the questions. There was a number of improvements on the written part of the report that were noted on page 9 and on page 3. Those been noted and those can be changed. Apart from that, I think we've answered all the questions.
No, thank you, Madam Spear. If you have a further follow-up, so the question on page 3.
Thanks, Chair. Apologies to the respondent. I didn't hear the answer with regards to the process of appointing auditors being with the licensee. He only answered the paying part, but that's part of the issue. I just wanted to hear the response with regards to them appointing, even though we are doing the scope. If I can have a response to that one, please. Thank you.
And the associated conflict of interest. Possible conflict of interest. Mr. Hopkins?
Yes, and to mitigate that. Thank you.
Yes, that hasn't been done in the past. The idea was that the licensee normally has to appoint a consultant, a whole maintenance plan for the network. They do that, every 5 to 10 years. And it might be cost effective to use that same licensee who is paid by the same consultant who's paid by the licensee. We can give him some to do the technical inspection for us, which he's busy doing for the licensee anyway. That was the idea. It hasn't been done before, and yes, there are questions about how it will work and will it be appropriate and things like that. We've never done it before, but we just left it open in the framework of circumstance. I don't know if that answers the question.
But the issue that we need to be able to then indicate how we deal with the potential conflict of interest, if we so allow that, and also the fact that I guess if the licensee is paying for somebody, what's the tune? So that is the issue at play here. But anyway, can I then request that as you've indicated that there is no immediate agency on this, and the request by members is that we take this document, enhance it, and when you submit it, perhaps we have at NERSA, and then we'll also indicate what other consultations you've done with other divisions as well as with LAS. And then, of course, I think it would be useful for us to, in the document itself, to indicate how it links to Section 32 of the Act, the investigations by the regulator, and perhaps there is some indication at the bottom there where it talks to a section of the license, but that is also always linked with the possibility of a Section 18 tribunal process. Maybe if we can then just take this document, repackage it again, consult with other divisions as well as consult with LAS or at this document going forward. Mr. Mkiza, do you still want to add something?
I just want to add something, but leave it not for the response now, to say to the team, look at Section 17. I think when we're dealing with the municipality, I can't remember that municipality, but it was more under, I think it was under administration, and there were issues there. If you can look at Section 17 in terms of this framework and try to expand on that, how you address it, whether you're going to have to revise rules or regulation or whatever that goes with it, in terms of revocation, to say that a regulator may revoke a license on the application of a licensee if, and it lists others, but D says conditions of a license are not met. And then 17 subsection 3, Minister prescribed to look at 18 is to indicate, especially when it comes to subsection 5, in terms of the extent and of the non-compliance in deciding the amount of any penalty. They still leave things wide open, and these are what are linked with compliance. And I'm not expecting a response now, but I'm saying that in going to review the document, please also, I have highlighted in the past the need for the team to go look at the sections that we need to have rules or regulations whatever, so that we are not the ones that are even contravening our own legislation by not actioning those parts. I will leave it at that. Thank you.
Thank you, Mr. Mkhize. And yes, your request of the past is noted, and we've raised this a few times. So, team, you revise it, but you consult accordingly. But please talk to those links and talk to LAS. They will greatly assist, especially because there are lots of cases that they are dealing with, and introduce the link to the national treasury processes that we are aware of in terms of to introduce a particular amendment to ERA. But some of these issues, the question is, can they be incorporated in terms of this compliance framework? With that, members, can we then step over to item 11, please? Mr. Mavuso, who's presenting item 11?
Yes, this one will be done by Rendani and Sepo. So I won't be Rendani and Sepo, can you come in?
Okay. By the way, Mr. Mavuso, your line is terrible. We can hardly hear you, so please reposition your mic.
Good morning, everyone. So this is so the title of this submission is Appropriate Recordal of Schedule 1 and 3 of St. Lake Electricity Distribution License for Mangaung Metropolitan Municipality Area of Supply. So the purpose of this submission is to request the Electricity Subcommittee to note the appropriate recordal of Schedule 1 and 3 of St. Lake Electricity Distribution License number NERDFS 172 for Mangaung Metropolitan. Team did conduct the confirmation meeting for electricity supply areas within Mangaung Metropolitan Municipality boundary with ESCOM distribution in Free State, and as well as St. Lake. This was done on the 7th to the 8th of December 2021. The delay between the meeting and the submission for noting for St. Lake areas of supply within Mangaung Metropolitan Municipality is the allocation of the NED numbers and the correction or redrawing of the supply area polygons, and as well as the unavailability of the ESCOM seconded project. This was also because of COVID as well. Is that based on the information contained here, it is recommended that the notes the following: the appropriate recordal of Schedule 1 and 3 of St. Lake Electricity Metropolitan Area of Supply with corresponding JS polygons. The other second recommendation is that the updated Schedule 1 of St. Lake Electricity Distribution license. Yeah, thank you, Chair.
Sorry. Thank you for the presentation, Rendani. We've got the presentation, we've got the document before us. Any comments, questions, members? Seems like it's a clear, it's nicely presented, and it's a clearly laid out submission. There are no questions or comments. With that, members can identify, and the decision that is sought is on paragraph 8.1, which I think has been read properly by Rendani. If we can then, members, by show of hands, can we approve the recommendation? It's here for noting. Thank you, Madam Massetti. Thank you, Mr. Mkhize. Thank you. I also note that was your decision. By the way, how do I say your surname properly, Rendani?
Chikudo.
Okay.
Okay,
all right.
thank you.
Mr. Mkhize, follow up. Lingering hand.
Sorry, sir, it's a lingering hand because I'm using a different instrument. I'm struggling with raising and lowering.
Mr. Mkhize. Let's go to item 12. Mr. Mavuso, hopefully your mic has improved. Mr. Mavuso?
I'll move position. Can you hear me? Can you hear me?
It's better. Your voice wasn't projecting properly, but it's fine. Please proceed.
Okay, Chair, will be done by Elvis, but it's just mentioned that this project is actually inspired by our APP, and that was the requirement that came from that we have this project plan. Thanks very much.
Thank you, Mr. Mavuso. Mr. Matikwan, over to you.
Good morning, Chair. I'll step in for Elvis. My name is Chisilo.
Yes,
Chair,
Mwanza.
the purpose of this submission is to request the electricity subcommittee to approve the electricity generation enforcement plan for 2024. This plan was informed by or triggered by the compliance to the APP. Chair, I will take this submission as read. I'll therefore go straight to the recommendations that are set out in section 14 of this submission. It is recommended that the electricity plan for 2023-2024. Thank you.
Thank you, Mr. Mwanza. I think it would have been useful to indicate that previously you were reporting only once, but the APP requested that report per quarter, and that is what the change is. It's a move from an annual report. Members, any comments, questions on the presentation? None. If there are no questions or comments, members, the recommendation is for the ELS to approve the actual generation compliance and enforcement plan for 23-24. By show of hands, members, if we can approve that, it's ready just to move from one annual to quarterly reports. Thank you, Madam Aseti. Any other? Thank you, Madam Spear. Thank you, Mr. Mkize. I also support quarterly reports. With that, can I then take you to the item number 13? Mr. Mavuso, who's presenting this one. This is a more difficult one, items 13 and 14.
Yes, Chair, this is a difficult one, but I would like to make intro remarks on this one. Just to say, this submission actually emanates from the work that has been done by the President, and to promote rooftop solar. And there's a framework that has been developed that we, as NESA, we are asked to process, including that we've developed rules. And I have to say, Chair, that there's been some major centers in terms of interpretation where NESA's rule starts and stops, and we were caught up in this process. So what we've done was to actually, and then put like for public scrutiny. But I just want details. Thanks very much.
Thank you.
Good morning, Chairperson. Good morning, members of the ELS and colleagues. The purpose of this submission is to request the approval for consulting on net billing rules that will be earmarked for stakeholders and members of the public. But I think Mr. Mavuso has covered them. We have to develop these rules based on the net billing framework that was developed by the NICOM Workstream 3. And as indicated earlier, it's a process that was done outside NESA, that now we were requested at some point to adopt, that we standardized it amongst licensees. So in order to do that, we have to develop the net billing rules. So what actually happened in the beginning is that when we processed these rules, we found that there was no legal basis to really look into processing. Getting legal advice, we were requested not to use that clause, but also to seek at the Disaster Management Act, which is the act that was, the regulations that were developed on the 27th of February, that also needed to be, it's section 5.1K of the state of. So at this juncture, we had to process these rules. Hence, even on the documents that was, we had made an addendum to change the legal clauses that were put in on the consultation paper and the rules themselves. So in that aspect, I will go on to the ask the committee to approve the net billing rules consultation paper that is attached, and also note the work that was developed by NICOM Workstream and also the indicative timelines for consultation. Thank you, Chair.
Thank you, Mr. Mooroy. Members, so the team is a consultation paper, and also note the net billing rules, the proposed net billing framework, and also to note the indicators. We will still have pre-hearing meetings on this, and we'll also have a post-hearing meeting on this. Yes. But of course, so there will be further opportunities to engage in detail with the contents. But any preliminary meeting?
Chairperson, strive to also just consult and work, Chairperson, but to the extent that the interpretation of these rules and some of the measures that are put or proposed in this document, we must implement it practically. What it would, we do get that that checked properly, Chairperson. And then with regards to see here in terms of what is required, the decision that is required, it says we must approve the consultation paper. May I request that we must rather note the consultation paper and then approve the publication. Thank you, Chairperson.
Thank you, Madam Massetti, for the rewording. So it's a reworded that subparagraph A be reworded to that we note the consultation paper and approve the actual publication. Mr. Mkhize?
Thanks, Chairperson. Without repeating what my colleague has said, I think it will also be important when I look at the introduction situation that we are facing an electricity crisis. And then to make a reference to the I think they've just to highlight that part of the Disaster Management Act. I see that it is at the bottom of page 3 there, because that's what informs this. Because when you look at the first, noting that this is as a result that we're actually having a state of disaster when it comes to electricity, then that for me is important because it shows it is the context in why them now. And I support that we note and approve the publication for public comment. Thank you.
Thank you, Mr. Mkhize. Most of these are just enhancement. We are talking to LAS. LAS has been involved.
Future engagements with the work that is done outside NERSA, and I heard that Mr. Documents that we also didn't know how to deal with them. It was a bit difficult for us as its rules. Thank you, Chair.
We'll deal with in detail when this matter comes before us for a proper decision after the consultation or before the actual decision, a pre-hearing meeting. Is that the issue here? It's about how do we link anything that comes outside of the, perhaps that question is, how do you link this request to the era? Because everything that we do of statute, and we are driven by our legal prescripts. So we need to be able to directly link any request and a part of the law, or if not, to link it to a policy, so that we'll be able to then say we are doing this and we are empowered to do it straight and basically do something that is ultra vires outside of our scope and jurisdiction. So that is in the main the biggest challenge here, but it's something that we'll actually deal with in detail when to us for a proper analysis. So members, basically, as indicated, the team is here to request that ELS notes the consultation paper on the net billing rules, attached here to as Annexure A, and approve its publication for public comment, and also note the rules and note the net billing framework and also the timelines. Mr. Mkhize, is that a decision, I hope? Your hand is up for a decision?
For a decision, sir.
All right, thank you. Members, if you by show of hands, thank you, Mr. Pokula. Thank you, Madam Masset, to support Madam Spear. Mr. Mavuso, who's presenting this one?
Initially served at the November ELS last year, And then the members had some concerns, and one of the concerns concerned the two court cases. And then we were asked to actually find some legal advice on this. We did actually find the legal advice on Friday with the senior counsel, who basically advised that we go ahead with this process, given in one of the judgments. And then I would like to ask Modiseni immediately after that to come and give us what the legal implication is. Thanks, Chair.
Thank you, Mr. Mavuso. Mr. Chabalala, over to you.
Thank you. So I'll be taking you through the municipal guideline increase and benchmark submission. So in the submission of the consultation paper for stakeholder consultation on the municipal, this has always resulted in these guidelines being finalized and published late, making it near impossible for municipalities to finalize their budgets on time. So what the team then resorted to is to say that this time round, the team actually took a different direction in trying to circumvent this problem by removing the dependency on ERTA. The first submission served in the ELS of the 8th of November, like ensure that licensees could budget on time, while also then allowing NERSA sufficient time to consider your 176 odd municipal tariff applications. So in a nutshell, Chairperson, this submission was rejected on the basis, one of the bases for rejecting the submission was to say that it was on the basis that consulting on a guideline increase number that was unlikely served little to no purpose for the industry. And the team was then urged to wait for the ERTA process to unfold instead. And then the actual detailed discussions of this meeting has been summarized in table 1 of the submission. So, Chair, the other key issue that I would just highlight from this meeting is the issue of the courts having declared the use of the guideline increase and benchmarks methodology as illegal. So it was uncertain at the time. We presented the submission for the first time. So the team was then urged to sort of get an interpretation to ensure that we are well indeed within our rights to use this methodology. I will not touch extensively on this issue because, like Mr. Mavuso had indicated, legal is going to be given an opportunity to sort of digest or break down some of the details surrounding these court cases. So, like I said, briefly on this issue. So in a nutshell, the Nelson Mandela Court case declared that the use of the guideline increase, put it differently, the Nelson Mandela Court case declared the use of the guideline increase and benchmarks methodology served initially. There was actually a similar court case brought by Casting against City Power, also making what appeared to be a judgment against the use of this methodology. So the only difference is that this judgment then did not grant us the 12-month grace period to correct any defect in our methodology. So the team since proceeded to seek legal advice on the matter in terms of the applicability of these guidelines. And the long story short of this one, Chair, is that our lawyers that we've consulted, senior counsel, has given us the go-ahead to use these guidelines, meaning that the 12-month grace period is actually enforced. But like I said, legal will have the opportunity to sort of discuss this issue in a bit more, in more detail. And then lastly, Chair, what I would like to just touch on briefly is to say that members, as a team, we have flagged a risk that in the event that these guideline increase and benchmarks are not approved, we will at our disposal with which to approve the municipal tariffs for the 2020-2024 period, which is starting on the 1st of July. This is mainly because one of the reasons is that there's no other approach that the licensees know. And be expected to sort of finalize an alternative is insufficient for any sort of meaningful engagement with licensees that would allow for a sort of a successful changeover from the guideline to any sufficient time to prepare themselves. There is high reluctance from the office to sort of approve any form of condonation in terms of missing some of these timelines. If you can just bear with me, I'm finalizing, Chair. So at this point, I would just like 23-24. So what we are looking at is only for the financial year 2023-24, starting on 1 July. So what we are saying with this is that the team will actually then come back to the ELS with a comprehensive plan to publish this consultation paper today. This will then allow for the ER to make a final decision on the matter by the 24th of May. What this means is that the team would actually below the 176 odd municipal tariff applications. I just felt that it might be important to mention that should we miss this opportunity, it is highly unlikely that we'll be application of the consultation paper. Before I hand over to you, Chairperson, may I request that legal provide members with more context around the court cases. Thank you, Chair.
Thank you.
Chair, thank you and good morning once more. Chair, I think this has been one matter that 5 topics requires maybe clarity to deal with this issue. And the first one being the context of the 2 judgments. Chair, we had judgments that all the parties have to present. And in the first judgment, in the casting judgment, the cause of action was a dispute raised by a customer against the tariff that City Power was charging the customer, or City Power is charging the customer. The nexus between the two is that there is a municipal tariff guideline, but only one judgment, which is the Nelson Mandela, dealt with the issue of the municipal tariff guideline and declared the usage of it invalid. But that decision, that order was suspended or is suspended for which 12 months, the 12 month is lapsing towards end September 2023. The court allowed the regulator to utilize in the guideline. Therefore, the regulator, in terms of the effect of that judgment, cannot use the guideline post September 20 on the determination of municipal tariffs from 23, 24, 25 in a state that to date when the court decided. The judgment of casting involving City Power primarily dealt with the issue of a dispute of a tariff where the court, in its reasons for judgment, and I need to say, Chair, that the 2 judgments were made by the same judge. The attorneys for those matters were the same in those cases. So when the judgment, one was made in October 2022 and the other one was made in November 2022. So they followed each other, with Nelson Mandela being the first one. The judge made in the reasons for judgment that the usage of the guideline by the regulator to determine the tariff of in the statutory provision, which is section 15, that the tariff determined for City Power with regard to those customers had to be reviewed and set aside. But I need to also emphasize that the casting judgment focused on a dispute between the parties, and the court ordered that the parties should engage on the matter. If they're not agreed, then the matter should be referred back to the regulator for decision. And the court did not outline the that should be used to determine that dispute, because the very judge was alive to the fact that the guideline that has been declared invalid has been given a grace period within which the regulator can the dispute. So, Chair, I need again on the aspect that is there an option? Is there an alternative to using, going back to the Nelson Mandela? So every party walking out of that case are alive to the fact that the regulator has been given a leeway to utilize the guideline to determine the 23-24 tariffs. But that will be done with the changes that are being developed for usage post-September. Risk that the regulator may sit down with. For time immemorial, the regulator has been using the guideline to determine the tariff. We had deliberations on the Section 10. It will require the development of a methodology that will then be, and that will enable the regulator to deal with the tariffs of the municipality. And the timeline that the Municipal Finance Management Act has set, it will not be achievable for to finalize a methodology that will deal with that. So the alternative the alternative becomes very thin and not advisable to consider, because we'll end up with what Mr. Chabalala has touched on, to say the outcome might be disastrous to both the regulator and the industry. The other issue that from the judgment one would need to highlight to the members and to give comfort is to determine whether is there fatality on the ability of the regulator to utilize the guideline. I've touched on that aspect, Chairperson, that there is no such, because the two judgments, the casting and the Nelson Mandela, they deal with separate issues that can be ventilated. The nexus between the tariff that was a challenge in the casting and the guideline, which was a challenge in the Nelson Mandela, to utilize the methodology within the time period that the court has set for the regulator to utilize, which is the end of September. Therefore, our consulted with senior counsel, where senior counsel as early as late as yesterday provided us with an opinion to say the methodology that in the Nelson Mandela case, it is still valid and usable. So therefore, our recommendation is aligned with that of the senior counsel to say there is no threat of lawfulness in the guideline to determine the municipal tariffs for the period 23-24 because of the insulation by what the judge has made in order 2 of the Nelson Mandela Bay judgment. Chair, I will pause. Thank you very much.
Thank you, Mr. Murati. Thank you, Mr. Chavala. Because of the questions that have been previously asked by members, I thought it's more prudent that they provide as much response up front before we allow members to for questions and to actually pose questions on this. But in the main, to also note that what the team is here for is to request we'll have a pre-meeting on this, assuming that there will be a public hearing on this one. But we'll have a pre-meeting, so members will get an opportunity to engage with the content later on as well. But I would like to then open the session up for members to ask questions or to comment on the process requested by the team. If there are any questions, maybe of legal nature or any other, starting with yourself, Madam Massetti.
Chairperson, I would like to start where Mr. Murati ended, that there is no threat if we continue to use the methodology. I would like to pose a concern with that statement, and that concern relates to the period that is prescribed by the court in its judgment, that period of 12 months. Because for us to be sort of taking this advice, we must know when does that period start and when does it end. We must understand what is the end of that 12 months. When does it start? When does it end? Because we do not want to have a tariff that will then have to sort of expire in October or December 2023, and then the licensees proceed to charge a tariff that does not enjoy legal protection. So we must at least be clarified on that aspect. at least from my side, Chairperson. I would like clarification on that. The second one, and I know that we're discussing these issues in the public domain, methodology, but I would have wanted to hear what the team has done with regards to the deliberations that took place in this subcommittee, where the members of this subcommittee applied themselves to the very same issue, and having considered the potential risk in continuing with the methodology the way that it is, and also trying to insulate NERSA from any future challenge without any other to show that we are complying with the judgment and the order that has been put down by the. So I'm referring here to the concerns about the period, as well as the prop from Mr. Bukula. Always stick to it as a rule book, but we could still indicate that we will use our discretion, being guided by Section 15, find a way of sort of referring to that sort of as a benchmark of some sort, but as a rule book that we use to determine the tariffs for and all to that input that was provided. And I'm not sure whether they have taken it to heart and whether they have done anything with regards to the guidance that was provided by this subcommittee. And I worry that they did not touch on that, to what extent they'd considered that input. Thank you, Chair.
Thank you, Madam. Any further inputs, members? If not, can I then hand back to you, Mr. Chabalala and Mr. Murati? Can I guide, though, that on a matter that is, I think the issue that was raised by Madam Massetti is a governance matter, but I stand corrected. What I'm guiding is that in your response, do consider the issue that may have been raised in committee in public platform like this. But you need to then still respond, but without necessarily breaking those confidentiality issues that may have been raised. So over to you, Mr. Chawala, assisted by Mr. Murat. First question, please. I think that's more a legal question about the validity anyway. Mr. Murati, maybe you can assist with a response.
Thank you, Chairperson. And the computer provided by the courts, one would need to look at it from what was it aimed was. The answer to that is that the judgment is aimed at the ability of the regulator to exercise its mandate, its powers to declaration of the decision. So the time period which started from November 20, it's only lapsing in October 2020, September, October 2023. But that is in as far as the decision making. Once the decision is made been exercised within the time frame that the court has enabled the regulator to, the operation of it beyond until such time that either the regulator has determined or a statutory provision applicable. Not, Madam Massetti, it's not related to the operation of the decision. It's related to the decision-making ability of the energy regulator. Thank you.
Thank you, Mr. Murati. Yeah, if you can attempt question 2, yeah.
Yes, as possible. And what we could do is that, remember, by the time of us submitting the submission, got our a response from senior counsel as late as yesterday already. So there are aspects in the submission whereby we'll admit that they would need some enhancement and updating, and that will be done. Including that section that you were referring to, Ms. Massetti, the issue that was raised by Mr. Bukula, and those will be extensively covered in the revision of the submission. Thank you, Chair.
Thank you. Mr. Mkiza?
I had to to make sure that I understood Mr. Murati correctly, that the 12 months applies to the decision, and once the decision has been taken, that decision will then prevail for the period of its tenure until we need to then take a new decision. In other words, this 12 months doesn't say that once we've taken a decision, we must develop this method within the 12 months such that we'll then have got to intervene before the duration or I understood him correctly.
Thank you, Mr. Mkhize. Mr. Murati, could you just reiterate, please?
Chair, yes, it is correct that the separation is between the decision and the tenure of the decision. The only issue that was is that if ever a municipality that brings an application in terms of MFMA in the period 6 months after the decision, able to attend to that application because the time period which the court has given as a grace period have lapsed. Therefore, the regulator will have to be having a new methodology that will be applicable to that. But for purposes of the coming municipal tariff decision, the regulator is insulated and able to make decision on the municipal tariff applications.
There is a follow-up, Mr. Murati, but maybe before what we need to remember is that the decisions of the regulator, once we've made a decision as the regulator, that decision remains valid until, of course, it is taken on review, if it's taken on review, or until a new decision is made. So once the decision is made, say by the 30th of June, that decision will remain that. And the question is, in making that decision, the methodology that we were employing, was it valid or not? Time of the decision, the methodology that we were using was deemed to be valid. Then we made a valid decision. Murati has previously indicated, even invalid decisions, even illegal decisions, they remain valid until they are changed until they are revoked. But this particular one is that what we are saying is that the methodology would still be deemed to be the guideline, but subsequent to that is that decision, those decisions are taken on review. But Madam Assetti, I recognize your hand.
Thank you, Chairperson. Methodology is invalid, but that it doesn't want to leave the regulator in terms of regulating the industry. So it gave us 12 months. So it means we must move with speed to come up with something, a mechanism that we're going to use in reviewing the applications. So that is the difference now that we have. Now, period of the effect of the decision, because it means the decision, the effects of the decision will persist beyond the grace period of 12 months. That's where my concern is. It will persist beyond the grace period of 12 months. And Mr. Murati seems to be saying that is okay for as long as the date of the decision was still within that 12 months. But it means that decision goes beyond that because the effects and the implementation of that decision goes beyond the 12 months. And that's where I have a problem. And with his interpretation, even if we're in the 11th month of the 12 months, October 2023, even if we're to take a decision in September, it means NERSA will still be fine. Then you have another 12 months when the one that was prescribed by the court has ended in 2023 October, then we will still go on until the following year. And that's in the way that we're interpreting this. We could even say that decision when we are left with only 8 days of that 12 months, if we go along with the interpretation that has been given. And I'm wondering whether that is the right way of looking at it. I am concerned, but I'm not taking the matter further, Chairperson. But I wanted to put that emphasis.
The way I would look at it, Madam Asset, is that at any rate, if we have not made a decision in terms of municipal tariff by the 30th of June, we would have failed that municipality, because its financial year is starting on the 1st of July. So, and that municipality would therefore not have a tariff to charge. So the decision, although we may have leeway to use the material until end of September or early October, but in fact, in reality, we only have until by the 30th of June in terms of a particular municipal tariff. Then that municipality would not have a tariff. See, Madam Kiza, do you want to elaborate a little bit further?
I'd just like to highlight the court order, number 3 there on the court order. The court actually makes it very clear when the regulator is prohibited from using this guideline from. And it's specific that it's the 2024-5 municipal finance year. So that would be, the 1st of July for that 2024-2025. So exactly what Mr. saying is correct. We are not prohibited from using this guideline by for the 2023-24 year. So or not, and using it if it's not published. I think we just want to highlight the Section 85 together with the principle of transparency and accountability that the courts have just emphasized that the decisions of NERSA are made public at the end, and the rationale that we use behind that the public. So whether whether we publish that now or not, we will still be making reference to it in the decision. So we still think, in keeping with 35, we would still need to publish that. Thank you, Chair.
Thank you, Madam Kiza. Members, we've been at this for a while. I think I just allowed it just that at least I know it is a different, but at this stage, as I've indicated, members, at this stage, the team is just here to request that the consultation paper be published. And if we don't publish the consultation paper and start the process, we would have robbed ourselves of an opportunity of even using this methodology, because the timelines are very tight on this one. So my request, members, is that we then go to paragraph 14 and basically, and then approve that it be published it be published for stakeholder consult on the NERSA website, Facebook page, and Twitter pages, as well as in government gazettes and in local news. Don't rob ourselves of an opportunity to still use this, even if we may have some discomfort on as we engage further on this, especially if we're going to have a public consultation, a public hearings, for instance. So, members, can I take you to the decision that is sought? It's on it's paragraph number 14. I offer, members, if we can approve the actual note. Thank you, Mr. Mkiza. Thank you, Madam Spear. Thank you, Mr. Pokola. I also support. And Madam Aseti, we note your concerns. I don't know concerns that have been raised by members. Thank you, members, for the decision. Sorry for taking too long, but I thought it was important that we give this one. Now we're going to pick up speed again. Item is rendered, but the item itself is indicated as item number 18. Over to you, Mr. Mavuso. Can I give you 3 minutes, please, guys, to present this coming ones? Thank you.
Thanks, Sir. Walile will present this. I will just let him.
Thank you. Mr. Mkiza Jr., please present.
Chair, I will take this one. Can I continue?
Oh, no, that's fine. Please continue, Ms. Makuban.
Thank you. Good day, members and colleagues. I will just quickly take you through this section 34 for the procurement nation as received from Minister, as well as approve the reasons for decisions that are attached here to as Annexure A. This determination is with regards to the procurement of 75 megawatts of solar PV, 19.5 megawatts of solar PV, as well as 100 megawatts of solar PV, which will be located in Letabo Power Station, Siri Wind Farm, and Komati Power Station, respectively, as well as 150 megawatts. Stakeholders responded supportive of the determination, with some issues raised, including the inefficiency, or rather the inadequacy of the allocation in terms of the quantum. There were also queries ensuring that inefficient costs are not passed through to the end-use customers, as well as ensuring that there is the procurement, given the challenges that have plagued the utility. Stakeholders have also indicated being supportive of sufficient or assist towards the sustainability of these mining towns. Just to highlight to members that the determination also responds to some of the NECOM initiatives, as indicated in that roadmap on page 26 of the stations that are due to be commissioned, particularly before and after 2030. Also, the inclusion of battery and energy storage is supported, as the combination of RE and battery would better support the grid, and this should be encouraged, particularly given the rise in solar PV, in particular through the registration regime. I want to take members to the recommendations on page 7 of 56, where we are requesting the decision to concur with the draft determination for the procurement of 344.5 megawatts capacity from solar PV and battery energy storage by Eskom, as well as the approval of the draft reasons for decisions. Thank you, Chair.
Thank you, Madam Makuwana. Just to correct, we are recommending to ER for approval. Apologies. Yes. No, yes. That's okay. Members, you've got the submission before us. Any questions? Onto the record, but we are recommending to the energy regulator. Thank you, Mr. Pokula. Thank you, Mr. Spear. Thank you, Mr. Mkize. Thank you, Madam Aseti. I also support the actual recommendation. Thank you, Madam Akwanik. To item 16. This one is the approval of a round robin. So members are not even going to ask Mr. Mavuso to present it. Members, this is just for noting. Mr. Pokula was on leave, and all members of Robin, and that matter then. So this is just for confirmation, members, by show of hands, if we can confirm. But Mr. Mkize, I see your hand is up.
Yeah, I just wanted to check, Chairperson, which matters in the beginning, because I'm starting to be confused now, because maybe I didn't hear you well, because my connection was not that 15, 16, 17 are not part of this. And secondly, I would prefer that maybe we close the meeting to the public at this juncture, and then we proceed with it to note. We do the rest of the noting in a closed meeting. Thank you.
Firstly, I think it's actually labeled on the agenda. It is item number 16. Additional items number 15, 16, and 17 were withdrawn. And which are those items? Those were also Section 34s, but unfortunately there were objections. There were parties that requested to present. So with the decision was that it's better to then allow those parties that wanted to present to actually have a public hearing first on those 3 items, and then those items will then be brought back to ELS for a decision. So apologies if it wasn't too clear, but it's actually 3 Section 34s. So in fact, we were supposed to have dealt with 4 Section 34s today for recommendation to ER. But because there were parties that wanted to actually make a presentation, we then requested that the team requested that those items be removed from the agenda, and they would be dealt with in a subsequent or any other ELS that then follows. I'm hoping that is clear. On the second request, I would have thought that because this was a round robin, that at least for the record, for the public, so that the public understands that those decisions because we're not making any new decisions in terms of those round robins. I don't know, but I actually stand by it. Mr. Ntanzi?
Chair, I confirm your approach is the correct one. Let's regulate in the sunshine. Thanks.
Thank you, Mr. Ntanzi. So that's what I would have thought. Decision has been made on a round robin by members, but by show of hands, can we then just confirm the decision, members? Thank you, Mr. Mkhize, Madam Massetti, Mr. Kokula, Madam Spear. I also approve. The next one also is just for noting again. We're noting it's something similar. It was was recommended, and via a round robin, that we also note this by show of hands, members. Mr. Kokula, Mr. Mkhize, Madam Massetti, Ms. Spear. I also note. Thank you, members. This actually brings us to the end of the open meeting. I'd like to thank the public that made